Hi, everyone. Welcome to the webinar, Estate Planning 101, Why is Probate Bad? I'm Stephanie Himel-Nelson, and you're also going to see Maria, my assistant, throughout this webinar, or you may hear her. And I'm so glad that you're joining us today. I hope that you're going to learn a lot, and this is going to be a really great use of your time. Now, for the next hour, I'm going to share with you all of the essentials of estate planning and what every adult needs in place. There are a lot of misconceptions out there. So my goal for today is to ensure that you walk away understanding what you need in place to protect your family. And the best way to get the most out of your time on this webinar is to turn off your phone, close your door, and close out of Facebook or Instagram. You're going to get a lot more out of this if you put away all of these distractions. Just take this time for yourself and you can learn and ultimately help your family. And be sure to stick with me for the entire webinar because I have a bonus for each of you that I don't want you to miss out on. And that's going to happen at the end. So stay tuned for that. And I promise it's worth it. Now, in the chat, you're going to find a couple of forms. One is a feedback form for this webinar. And I'd love it if you could fill it out at the end of the webinar. You can tell me a little bit about what you hope to learn, what kind of planning you're looking for, if you have any topics you really want to hear more about in the future, or if you have any feedback or improvements that we can make on this webinar. I would love to hear that from you. It's a fillable PDF, so you can just fill it out right on your computer and then email it to me. My email is on the form. And you should also have gotten an email with the webinar workbook. And if you didn't for some reason, you can find that in the chat too and download it from there. If you don't see it for some reason, just drop a comment in the chat and Maria will get it to you. So if you have that printed out, just follow along. If not, just follow along on your computer and you can refer to this throughout the webinar. And this is going to help you stay engaged and make sure that you get the most out of the event instead of browsing your phone. Okay. And as we go, I want you to think about your questions and write them down in the workbook, or you can have them ready to ask at the end. Or as we're going through here, you can drop them in the chat and Maria's going to be watching for them to make sure that I get to them at the end. And then finally, I want you to think about the people in your life you care about the most. They're the reason you're here. We don't do estate planning for ourselves. We do it for the people that we care about. So before we dive into everything, I'd like to ask everyone on this call, do you have an estate plan in place? If not, what's kept you from getting your affairs in order up until now? Now, go ahead and you can drop your response in the chat, and Maria's going to be watching for your comments. So hopefully we can address your concerns as we go through this webinar today. Now, I realize that estate planning is not something that is fun to talk about or think about. In fact, almost 70% of Americans have no estate plan at all. No will, no trust, nothing. And many of you on the webinar are probably part of that 70% with no documents in place, no judgment at all. But comprehensive estate planning is about more than just having a will or a trust in place. So we're going to talk about the essential planning documents that you need, that every adult needs to have in place, especially if you have family members that depend on you or that you care about. So now we are on question number 1 in your workbook. What are the 3 biggest doubts that people have about estate planning? Now, first of all, I know there's this sort of fear that planning for death is somehow going to make it happen. You know, if you keep putting it off, just don't think about it. It's just, out of sight, out of mind. This is really common. So don't worry, it's totally normal. But it's also a reason you may be reluctant to discuss estate planning with your family or your parents or your own adult children if you have them. Another common objection that I hear is this is just going to take too long and I do not have the time to figure this out. And I totally understand that. So we're going to talk about this later in the webinar because I want you to know exactly how long the process is going to take, what's involved, and how much it costs so that you can plan from here. And then finally, I know that you may be wondering how estate planning benefits you. Isn't this something that just, people like your parents need to worry about? And is it really necessary if you're not a multimillionaire? And we're going to talk about that too. So if any of this sounds like you, just know that this is totally normal and you are in good company. Now, the good news is that I have never had a client sign their will and then drop dead right afterwards. And I'm going to knock on wood. But yes, getting an estate plan in place does require an investment of time and money. But I think you'll find that the benefits of estate planning far outweigh the costs, both financially and emotionally. And finally, you'll see as we go through this webinar that the benefits of estate plan really have nothing to do with how much money you have or how old you are. So this is something we should all care about. And at the end of the day, when we talk about estate planning, the big picture is this is not about you. It's about the people you love the most. So my idea of estate planning is that it's about making sure things are as easy and inexpensive as possible for your loved ones when you're gone. And you care about that no matter your age, and you care about that whether you have $10 in the bank or 10 million. So this is question number 2 in your workbook. Who are the people that you care about the most? Who are you doing this planning for? And I want you to write that down. Okay, so this is our agenda for today. You're going to get much of the same information that you get from me in a one-on-one personal consultation. First, we're going to talk about what happens if you die intestate, meaning without a will. We're going to discuss your 2 basic estate planning options, including the difference between a will and a trust, and how a trust can help you avoid probate. But by the end of the webinar, I want you to have an idea of what makes sense for your family, a will or a trust. And I know that many of the people on this webinar are parents of minor kids. So we're going to talk about the essential documents you need in place now to protect them as part of comprehensive estate planning. And I know that everyone wants to know, why is probate bad? Like the name of the webinar. So throughout this webinar, I'm going to mention probate. But when we talk about a will versus a trust, I'm going to more specifically talk about what probate is and how it can affect your family when you die. And then finally, I'm going to talk about how you can get started, what you need to get in place for comprehensive estate planning, which is a lot more than just creating a will or a trust. So we're going to cover all of that. I'm going to talk hopefully for about 45 minutes. I will try to keep my side commentary to a minimum, and then we'll have time for Q&A. So as part of our discussion about how to get started, we're going to discuss how to start the estate planning process with my firm, what's involved, and how much it will cost, because I know these are really important questions that you're going to have. So by the end of the webinar, you're going to have all the information you need to make a decision about your own estate plan and how to move forward with my firm, just like you would if we were sitting in a one-on-one personal consultation. And do not forget about your bonus at the very end. So a little bit about me. Again, I am Stephanie Himel-Nelson, and I am an estate planning attorney with Jennifer Porter Law. We are a military spouse-owned firm based in Northern Virginia and Hampton Roads. I've been a practicing Virginia attorney for 22 years, and I'm also a former military spouse. My husband is retired from the Navy. So here is all of my contact information. You can take a screenshot or a photo, or you can use that QR code right there to save my information. And please feel free to call or email if you have any questions at all. So just like many of you, my reason for being here, for doing this, is my family. I live in Virginia with my husband, who is, as I mentioned, retired from the Navy, and our 3 boys. One of them is off at college at Virginia Tech. Go Hokies. And our middle is about to head off to college at William & Mary. Go Tribe. And our youngest there is 10, and he's excited about Minecraft and his baseball team. So my husband and I, we have aging parents and college expenses and saving for retirement. And we also want to ensure that our youngest is cared for if something happens to us. So I get it. I get how overwhelming this entire process can be and how hard it can be to know just where do I start. So today I'm going to show you how to start planning. Now, before we jump into probate, I want to give you a little background about estate planning and what our goals are as we work together. So these are some of the things that estate planning accomplishes, and all of these are part of comprehensive estate planning. I'm going to just mention a couple of these really quickly because we're going to talk about most of these during the webinar, but think about which of these are important to you and your family. So your goals with estate planning, you want to make sure that you can give what you have to the people that you want in the way you want. You want to avoid probate court. You want to maximize the assets that your loved ones get. You may want to care for yourself during your lifetime. You may have charitable intentions that you want to fulfill. Everyone wants to minimize taxes at death, and you want to care for and protect the people you love. You may want to pass on your values and ideals to your children or grandchildren and protect assets from creditors, divorce, bankruptcy, or the government. So one of the questions I know you all have is, what documents do I need to get in place? And here you go. Here are the essential planning documents you need in place now. And we'll talk about some of these today, but in a one-on-one consultation with me, we'll actually talk about all of these. And today I'm going to talk a lot about comprehensive estate planning. And comprehensive planning means planning not just for your death, but for your potential incapacity. What happens if you and your partner are in a horrible accident and you can't tell your healthcare providers what care you'd like? How are your loved ones going to get information about your condition? These are the most important documents to have in place to ensure that you and your family are cared for in the event of your incapacity or death. So together, all of these documents help ensure that the people you trust can step in and help you and care for your kids if something happens to you. So all of these documents are included in comprehensive estate planning. Now, first up, what happens if you die without any estate planning in place? No will, no trust. I mentioned earlier that most people don't have an estate plan, 70%, or at least they think that they don't have an estate plan because they haven't formally created a will or a trust. But the truth is that you do have an estate plan, even if you haven't formally prepared documents. It's just that the Commonwealth of Virginia has written it for you. In other words, there are default rules that kick in when someone dies without doing any estate planning. You probably won't like the default rules, which is why we do estate planning, so you can override those rules for your family and your assets, and you can make those important decisions yourself instead of letting the state of Virginia make them for you. Now, if you die with no estate plan, no will, no trust, it's called dying intestate. And this may be the situation that many of you are in. This is the doing nothing scenario. And it means you'll end up with Virginia's default plan. So what is the default plan? In Virginia, if you die without a will, your assets are going to be distributed according to state law. That means you don't have control over who they go to. Your kids will get any inheritance at age 18 and outright. Your spouse could remarry after death and leave money to a new spouse and kids. A judge is going to decide who will raise your minor children, who's in control of your children's money, and your family is absolutely guaranteed to go to probate. So if you're okay with the default plan, as I just laid it out, you don't need to do any estate planning. But I have yet to meet someone who actually wants anything on this list to happen. Do you want Virginia law to decide who gets your estate? Most people say no. But what do I mean when I say estate? Tell me what you think about when I talk about estates. You can tell me in the chat. I really want to know. And then Maria can share with us. But personally, I always think of Miami Vice and those huge houses that you see at the beginning of the opening credits. And I think I just totally aged myself there. But many of us don't think we have an estate, that only really wealthy people have estates. But we all have some of these assets or accounts, including bank accounts, a house. You may have life insurance proceeds, a retirement account. You may even have like a coin or a stamp collection. You might have a small business, intellectual property. So this is your estate. All of this right here is your estate. But as part of estate planning, we need to decide where all of this is going to go when we pass away and under what circumstances. There are 3 ways that you can own property at your death, and this is question number 3 in your workbook. Individually, jointly, and with a beneficiary designation. So a bank account that you own, not jointly with anyone else, just you, is owned individually. And an account that you own with 2 or more owners, like a husband and wife, that's owned jointly. And an asset like life insurance or a 401k or TSP, has a set of instructions, a beneficiary designation, as to where it goes when you're gone. So this is the key. You still need to do estate planning, even if everything you own is held jointly with your spouse, or it all has a beneficiary designation. Now, you may be thinking, I don't need to do that because of the joint ownership. What are you talking about? If I die, everything just goes to them. And while it's true that jointly held assets do just go to the other owner when you pass away, we also have to account for what happens when the second owner dies, or if you die at the same time. Jointly owned assets avoid probate when the first of you passes away, but they will not avoid probate at the second death. And there I did it again. I mentioned probate again. Don't worry, we're going to get there. Sometimes, like life insurance, you have a built-in estate plan. It just gets paid to whoever you've named as the beneficiary when you pass away. So generally, these assets don't have to go through probate court, but that is assuming that the beneficiary is over the age of 18 and actually alive when you pass away. If either of those things are not true, those assets are also going to go through probate. So it's just as important that the proceeds will be paid outright. So let's say you have named your 19-year-old son as the beneficiary on your $500,000 life insurance policy. And where did I get that? I have a 19-year-old son. So with no rules as to how and when he can spend the money, might blow it in a week, he might buy a really expensive car. So sometimes a better idea is to set up a trust, name the trust as the beneficiary instead of your son, and then put some rules in place as to what he can spend the money on. Okay, I think we've pretty much established that you need an estate plan no matter what assets you have. So what are your options? And as we go through the two options, I want you to be thinking about which one makes more sense for you and your family. The foundation of any estate plan is a will or a trust. Now, this is question number 4 in your workbook. So go ahead and write that down. And you have two options. You're either going to do a will-based estate plan or a trust-based estate plan. This is a decision everyone has to make, whether you're married or single, kids, no kids, regardless of how much money you have to decide if you want a will or a trust. And I may not have mentioned this yet, but I'm going to go ahead now. But the vast majority of my clients and people today choose to do a trust instead of a will. But I really want you to understand both options, and I want you to understand the differences between a will and a trust. So first, let's look at a will. What does a will accomplish? Having a will is a good start. It's where you can name guardians for your minor kids. You can name beneficiaries for any asset or account held in your name alone, and you can name an executor. So this is the person who's in charge of wrapping up your affairs and an estate when you're gone. And those are the things that a will does. And it's about all that a will does. You can see that a will doesn't actually accomplish all that much, and it comes with some downsides that many people are unaware of. There are some pretty big downsides to having a will. First, wills have to go through probate court at death. And we're going to talk about this again. We're going to talk about why this can be a bad thing. Second, your will is only effective at your death. So it doesn't help at all if you're alive, but disabled, incapacitated, and unable to manage your own affairs. If you can't pay your bills or communicate your healthcare wishes, your will is not going to help at all. It's entirely possible that many of us will get to this point through age, illness, or accident. So that's something important to think about. Also, each state has their own laws regarding wills. So a Virginia will may not be effective in California or Florida. So if you have a Virginia will and then you move, you may have to redo your entire estate plan. This can be a problem for military families in particular, and many families move these days for jobs or personal reasons. Fourth, most parents don't want their kids to inherit everything when they turn 18, which is the age you're legally entitled to inherit money in most states. Most parents want their kids to get this later in life when they're a little more mature, they have a little more not financial knowledge. And you're not allowed to really put instructions in a will that says my kid can only inherit if they are 25 and have finished college. You can't do that in a will. You need a trust to do that. And as I said before, most assets are outside of the reach of a will and don't go planned for. Wills don't control a lot of property, including retirement plans, annuities, insurance policies, and anything that you hold jointly with someone else. Finally, a will simply transfers property at death. You can say, I want my money to go to my daughter when I pass away, but you can't say when she's 25 and has finished college or trade school. You aren't allowed to really put any instructions in a will for how and when the money is spent for your kids or grandkids or anyone. You need a trust to do that. Okay, it's finally time to talk about probate. Where there is a will, there is a probate. That means that if you die with a will, it must go through probate court before your money can be distributed to your family. And hopefully your court experience won't be as traumatizing as Colonel Jessup's here, but it won't be all that pleasant because court is never a very fun process. So what is probate court? So the main purpose of probate is to finalize your estate, pay off your bills, pay your final taxes, and then change the title on the property you own when you die from you to your family. Your executor will make a full inventory of your assets and appraise it. If anyone wants to contest the will, those disputes happen in probate court, and then the assets are distributed to your rightful beneficiaries, and a judge oversees this entire process. You'll need court permission to do anything. And typically your family's going to have to hire a lawyer because it's a complex process. There are 3 downsides to probate court. This is question number 5 in your workbook. It's expensive, it can take a long time, and it's a very public process. As I mentioned earlier in the webinar, there are a lot of fees that are associated with probating a will. Court fees, lawyer fees, executor fees, and those can eat up as much as 1 to 5% of the estate assets. These fees are going to reduce the amount of money that ultimately goes to your family. Okay, I love examples, so let's look at a real world example. Rebecca is a single woman. She has created a will that leaves everything to her daughter, Megan, who is currently 10 years old. Rebecca has a house that she lives in worth $400,000 and also a house she rents that is worth $100,000. She's got an investment account with $250,000 in it. She also has life insurance payable to a minor and a retirement account payable to a minor. And because minors cannot inherit property, these assets now have to go through probate court. So a judge can make sure that the money is being handled properly. So these assets become part of her probate estate, even though they wouldn't normally. So when we add all these assets up, the total probate estate is 1.8 million. And remember how I said earlier that probate can cost as much as 1 to 5% of the probate estate? Well, when Rebecca dies, her will leaves everything to Megan, and it's going to need to go to probate court. Her family's going to have to hire a lawyer to probate the will and handle a conservatorship for a minor because kids under 18 can't just inherit outright. So let's say it only ends up costing 2% of the total estate. That is still $36,000 lost in probate. This is $36,000 that is not going to Megan. It's going to lawyers, court, and probate fees. So this is a pretty big downside to dying with a will that most people are totally unaware of. The costs of probating that will at death could be significant, even for middle-class families. The second downside to probate is that it can take a long time. Even the simplest of estates can take months or years to probate. The minimum in Virginia is 6 months. Most of your assets are frozen for the duration, which is a problem if you're counting on money being available for the care of your minor children or the rest of your family. And it's an emotional burden for your family too. This drags the process of settling your affairs out over years if you have minor children. If you've got minor children, the court is going to have to oversee their money until they reach 18. You need court permission for virtually everything. This drags the process out for years, and it can be expensive. Finally, probate is a public process. And I think most of us would agree that there are a few things more private than your relationships with your loved ones and your financial situation. But if you die with a will, your estate is going to be a matter of public record. This means that anyone can go down to the courthouse, find out what assets you left behind, how much they're worth, and who you left them to. You'll end up sharing very personal information with anyone who cares to look. It can make your minor children vulnerable to all sorts of unsavory individuals because their names are going to be in your will, right alongside with how much money they will be inheriting when they turn 18. And another problem that some attorneys have encountered is that you will get sham claims. People hear about this, they'll go look up the will, they'll go see how much money is there, and they'll be like, oh, you know, there was that time that my neighbor backed into my car, and even though you've already resolved that 5 years ago, they're going to claim, oh, they never paid me. So a lot of things like this happen too. Vendors will claim, oh, I delivered all of this mulch and I was never paid for it, or we finished that roof and we were never paid for it because this is a public record. So this is the third downside to probate court, and it's a pretty big one. So if you think about these three things, which one bothers you the most? So you may be asking yourself, knowing all of these downsides, why would anyone do a will? And I get asked this question all the time once people see these downsides. And the answer is that if you have less than 50,000 when you pass away, you're eligible for a simplified probate process that's very easy and inexpensive. So in this case, a will may be sufficient. But if you have more than 50,000 and you want to avoid any of these three downsides we just discussed, a will may not be the best choice for your family. So are you scratching your head right now wondering if a will isn't going to do what I want it to do? What are my options? So let's look at option number 2. And this is to do something called a revocable living trust, or revocable living trust, depending on how you want to pronounce it. And again, this is the option that 90% of my clients choose. So what is a revocable living trust? I like to call it a will on steroids. It's a document that you create, which is very similar to a will. You list the people you want to inherit your money when you're gone. Just like a will, the trust is revocable. That means you can change it, you can revoke it entirely at any time. And your revocable living trust is going to have a trustee, and that is you. You're in charge of both the trust document itself and the assets that go into the trust. The way it works is you create and sign the trust document and you give it a name. Maybe it'll be the Jones Family Trust. Everything you own is now outside the trust, and you want to move your assets into the trust by retitling them. Remember, we talked about the importance of title earlier? Now, keep in mind, you still have total control over the assets that are in the trust. You can still use them, you can spend them, you can sell them. Nothing changes. You still treat your finances the same way you always have. You pay your taxes the way you always have. But the benefit is everything inside the trust goes to your named beneficiaries without going through probate. And this is big, don't you think? I feel like most people just aren't familiar with trusts and what they can do. So this is new information for a lot of people. Okay, the next question. Aren't trusts just for rich people? And if you're thinking that, you would be wrong, because trusts are definitely not just for wealthy people. So what is it really? What is a trust? Simply put, it's an agreement that spells out the rules you want followed for the assets owned by the trust when you pass away. That's it. So a trust solves all of the problems that people assume are solved by a will. So here's another real world example for us. We're going to look at Bob. Now, Bob has $100,000 in a bank account that he wants to go to his daughter, Ava, when he dies. But he wants Ava to be 25 and have finished college or trade school before she gets the money. Bob needs a trust. He's not wealthy. He's not setting up some fancy trust because he's leaving millions behind. He's just putting some rules in place. He wants Ava to be 25 before she inherits, and he wants her to have some education. Bob needs a trust to do this, even though he doesn't have a lot of money or a complicated estate, because he wants to control how and when his daughter gets his inheritance. That's it. Every trust has three roles: a seller or grantler, who is the person who moves the assets into the trust, a trustee, and that's the person who manages the trust assets, and a beneficiary, and that's the person entitled to receive those assets. And with a revocable living trust, you hold all three of those positions while you're alive. You're the grantor, the trustee, and the beneficiary. Another example, we have Harry and Wendy. Harry for husband, Wendy for wife. They set up a revocable living trust and they occupy all three positions. They have total control over their assets. They act as the grantors who create the trust and transfer title to their assets. They occupy the manager's role as the trustees who make all the decisions over the assets. And finally, they're also the beneficiaries of the trust. They have the right to spend and use the assets in any way they want. In other words, Harry and Wendy still have complete control over their assets, even though the assets are titled in their trust. What does it mean to be in total control? Well, it's just business as usual for Harry and Wendy. They can also amend their trust or even revoke it if they want to. They have all the rights to manage the property, and their income tax forms are filed exactly the same way they've always done them. The property taxes on their home are paid in exactly the same way. Because this is a revocable trust, the government ignores the trust for tax purposes and continues to tax Harry and Wendy as individuals. With the revocable living trust, the secret to avoiding probate is how you hold title to your assets. And we've touched upon this already. Remember how we talked about assets being owned individually, jointly, or with a beneficiary designation? Well, that comes into play here when we talk about revocable living trusts. Okay, we're on question number 6 in your workbook. So think of a revocable living trust like a kid's backpack. When your kids start school, they pick out a backpack and it can be any kind, any color, size. There's a million options. And your trust is the same way. You're going to set it up so it accomplishes what you want to accomplish it. And the goal is to have your trust hold all of your assets, because then those assets will be distributed according to the terms of your trust when you pass away. So your trust document is like the backpack. You set it up exactly how you want it. And then you move all of your assets into the trust. And then when you pass away, everything held by the trust goes to your family with no probate court involvement. So right now, all of your assets are in your name, which is bad. You want all of your assets to be held in the name of your trust. In other words, you want all of your assets to be inside the trust or inside the backpack. Again, funding your trust is simply changing the ownership or retitling your assets so the trust owns them instead of you. Just like this lady right here is putting all her stuff in her backpack, you're going to put all of your stuff into your trust. This solves many of the problems that come with a will. You're not going to lose 1 to 5% of your estate in probate court. Your assets can go to your family in weeks and months instead of years, and it's totally private during your life and at death. Some other benefits to a living trust. It's easy to amend. As your life changes, you can make changes to the trust document through amendments or restatements. The trust does not get a separate tax identity, so your income taxes don't change at all, doesn't make it hard. Your trust can cover all of your property, including beneficiary assets and jointly held assets. It's really not any more difficult to create and maintain a living trust than a will. But importantly, it's valid in all 50 states. So you don't have to redo your estate plan every time you move. Because it's a private document, nobody knows what's in it. So it's harder to contest, and it's harder for scammers to try to get in there. As part of your trust planning, we can also discuss strategies for managing an inheritance, gifts and estate taxes, and even protecting assets for your kids and your grandkids. Now, before we go on to the next slide, I'm going to ask you all about estate taxes. So how many of you are concerned about estate taxes your family might have to pay when you pass away? You can drop it in the chat and I'll give you just a minute, because this often tells me how much time I need to spend talking about estate taxes. Okay, we have some people who are concerned about estate taxes, so we'll talk about it quickly. Now, the estate tax is tax that's due when someone passes away if they have more than a certain amount in assets. Not just money. This will also include things like life insurance and retirement accounts with a direct beneficiary. So it's everything. So there's a federal estate tax, but we are lucky in Virginia to have no state estate tax. Yay. But if you are married and die with more than 27.2 million in assets, your state will have to pay federal estate taxes. I know that's like a pretty high number, right? And if you have 27.2 million, I would like you to adopt me. Thank you. But I have an asterisk here, and I'm sure you can all see that. The asterisk is here because that 27.2 million may revert to 5 million per person adjusted for inflation if Congress doesn't renew legislation by the end of 2025. So I'm just kind of assuming right now we're planning for our clients that it is going to revert to 5 million per person adjusted for inflation. So this may affect you now or in the future as your property values increase and your investments grow with age. If you're in this category, you can reduce your tax liability by doing more advanced estate planning with a trust that is beyond the scope of this webinar. But if you're interested in that, let me know on the feedback form or drop something in the chat, or you can just email me and we can talk more about it. Now, we've talked about what happens if you pass away without an estate plan. We've discussed the difference between a will and a trust, and we talked about probate and how it can affect your estate. But I know many of you on this webinar are parents. So in every webinar, I discuss minor children and the importance of nominating guardians. So this portion of the webinar is for parents of younger children. If you have minor children, that is kids under the age of 18 in Virginia, one of your top priorities is getting in writing who you want raising your children should something happen to you and your spouse or your partner. I ask all of my clients, and I'm going to ask all of you now, have you had a discussion with any family or friends about caring for your kids if something happens to you? And you can go ahead and share that in the chat if you're comfortable with it. And if you have kids and you haven't had that discussion with anyone, tell us what's holding you back and maybe we can address it. I know this is hard to think about, but I think parents of minor children need planning more than anyone, even people who are elderly, because there is really nothing more important than making sure that your kids are taken care of by the people you want, the way you want, no matter what. While a will or trust is the foundation of your estate plan, nominating guardians is the most important thing you will do in that estate plan. So the rule is if you have not nominated guardians in a will and you and your partner or spouse pass away, a judge will choose for you. In other words, a complete stranger is going to decide who gets permanent custody of your children. And because you didn't get your wishes down in writing, they have no choice to figure out what you would have wanted on their own, what's best for the kids. Just writing it in a letter or letting your sister know is not good enough. That is not legally binding. A judge is going to do the best that they can with the information that they have, but they don't know your family. They don't know the history. They don't know your preferences, and they don't know what you would have wanted. This is question number 7 in your workbook. If you don't nominate legal guardians for your children, who will name them for you? So a judge could end up naming someone who looks really great on paper, but you know in real life is the last person you would ever want raising your children. This happens in something called a permanent guardianship proceeding. In a permanent guardianship proceeding, a family or friend member, or a family member or friend would have to petition the court for custody of your children. And a judge would make the final decision about who's going to raise your kids. This kind of proceeding is challenging, it is complicated, it takes a long time, it's expensive, and it is intense. So you want to avoid this. And the way to do this is by setting up a will. This is the legal document where parents nominate guardians. Another reason you want to get your wishes in writing in a will is because what if more than one family member wants custody of your children? What if your sister wants custody of your kids, but so do your husband's parents? Now, some of you told us in the chat, I see there that you've had this discussion and you may be in this situation. So this is something I hear pretty often. A client will come to my office and say, well, there are just so many people in the family who love our kids and would take them, so we are fine. And this is actually a problem because if you haven't said which of those family members you prefer and in what order, your family may end up doing this out in court and your kids are going to get stuck in the middle of that, and you do not want that. So the solution is to create a will. You name your first choice for guardians for your kids. If it's a couple, you may want to say what happens if they get a divorce or one dies. You may name your sister Jennifer and her husband Tim. But if Jennifer dies, do you want the kids going to Tim? Maybe, maybe not. So you'll discuss this and you'll put it in your will. And you can list as many backups as you want, just in case your first choices aren't available or decline the appointment. So you may be wondering, if I do the revocable living trust, like you said, and not a will, where will I nominate guardians? Stephanie, didn't you say a will is the document where we list our guardians? And the answer is then when we create a revocable living trust, we also create a very basic will that goes with it. It's called a pour over will. And what it does is it pours any asset not in your trust at your death into your trust. So sort of a safety net. And we also use the pour over will to nominate guardians for your minor children. Now let's talk about comprehensive estate planning. I've used that term a lot during this webinar, but what the heck does that mean? So part of almost any discussion about comprehensive estate planning also involves talking about DIY or bare bones estate plans, because many people ask me, Stephanie, why can't I just make my own will or trust powers of attorney online? Now, DIY is great for crafts, but I would not recommend tearing out walls and trying to fix your own electricity unless you're an electrician, as this guy learns the hard way. And it's the same for estate planning. DIY plans, they don't work. So let's go ahead and talk about online estate plan forms. I call these cookie cutter plans. Now, it's important for you to understand what comprehensive estate planning is, not just estate planning, but comprehensive estate planning. And I keep saying that, right? What I can't tell you is that cookie cutter documents, DIY documents, are poorly drafted. They may not comply with Virginia laws, and they don't address real life issues that families face, like blended families or children with special needs, long-term care planning, estate tax issues. They're very basic, and they are not going to address many of the things that most of my clients, that most of you really care about. Another big problem with the cookie cutter documents is that they're usually just a will. That's it. And this is probably what you think of when you think of estate planning, right? The problem with a will is that, of course, as we discussed, it guarantees your family is going to go through probate court before getting access to your assets. And we talked a lot about the downsides of probate. Many people are surprised to hear that a will means you have to go through probate. They're operating under this false assumption that a will meet their needs and make things easier, but now you know that that's not necessarily true. Moreover, when your estate plan is just a will, it's not comprehensive. You also need to plan for incapacity. So what happens if you're no longer able to make or communicate your own healthcare decisions? What if you're in an accident and in the hospital and you can't pay your bills? Many of us worry about this for our parents, but what happens when our parents need help, But it can also happen to you. You remember at the beginning of this webinar when I mentioned all the elements that go into comprehensive estate planning? Well, planning for incapacity or illness while you're alive is a big part of that. And while it's uncomfortable to think about, comprehensive estate planning means planning for the best and planning for the worst. And it's part of my job as an attorney to ensure that we talk about that and we make a plan that complies with Virginia law and is actually enforceable. Cookie cutter plans are not going to do this for you. They also don't keep up with your life, because the truth is your life is going to change. Your assets and your family are going to change, and your estate plan needs to keep up with this, or it's not going to work when you need it to. And finally, the vast majority of cookie cutter estate plans just leave money outright to the kids at 18. And we already talked about why that can be a problem. Part of comprehensive estate planning involves addressing ways to protect an inheritance for your kids or grandkids. So as you can see, many of the fill in the blank or online estate plans, all of those DIY documents, they aren't sufficient and they don't always comply with Virginia law. This is why you need to work with a lawyer who will take the time to do comprehensive estate planning. Another recent trend I'm seeing are what we call bare bones trusts. Now, estate planning should be done by an estate planning attorney committed to providing a comprehensive estate plan. And there are less qualified options available today for families who may not know better. They're often produced by attorneys that don't focus on estate planning. You may have a family lawyer who just dabbles, or you could have an employer provided discount legal plan, or sometimes even non-attorneys will try to do this. Beware of these documents because, again, they may not comply with state law, and they don't contain the important personalized planning that's necessary to protect you and your family. They may be just as bare bones as the fill in the blank DIY documents we just talked about. And a lot of times we also see that these are not funded, which means even if a trust is set up, the assets are never moved into the trust. And because they're not funded, the estate plan is still going to end up going through probate. So I don't recommend doing a bare bones trust or trying to provide these by yourself. A better idea is to work with a lawyer. And here's what I want you to remember. When you work with an attorney, you are paying for guidance and counseling about how the documents should be drafted, not the documents themselves. It's the advice you need. So the information portion of the program is over. I promised at the beginning that I would tell you how to get started with your planning. So now we need to get an action plan in place and ask these basic questions. What do you need to do? How do you make it happen? When should you get started? And what's the investment to get it done right? Now, if you've worked with a lawyer before, you're probably somewhat familiar with hourly billing. This means the attorney keeps track of how much time they spend on your matter in 6 or 15-minute increments. This can be really stressful because you have no idea how much it's going to cost. Also, the traditional practice of law tends to be very reactive. The problem falls in your lap. You're reacting to the problem and trying to put out an expensive fire. And ultimately, you're a number. Your matter starts, your matter ends. You don't have any ongoing guidance on how to avoid problems in the future. At Jennifer Porter Law, we have flipped that traditional experience on its head. So everything I do is flat fee and agreed to in advance. You don't have to worry about being charged for every little call and email because we do not bill by the hour. You may have a million questions about your plan, and I can promise you that I have had clients who do, and it's all part of your flat fee, and that is fine. That's what we expect. Also, I love creating plans for our clients because it's very proactive. We're not responding to negative situations. It's all about making sure your family won't have to deal with an expensive mess when you're gone. And we really do value our relationships with our clients. I want to stay in touch with you over the years because I know that your estate plan is not something that you just do once and then never think about again. When your life changes and the law changes, and it will, we want your plan to keep up. So here we have our virtual estate planning process. First, you attend a peace of mind planning session, which is a one-on-one consultation with me that lasts about an hour. This costs $400, but we apply this $400 towards any estate planning work that we do for you. Before the session, I ask you to fill out an online questionnaire. And this asks some basic questions about your family and your assets so that I can start to gather information needed to draft your documents. And in your planning session, I hear more about your goals and concerns. We look at your personal and financial situation, and I talk about your options thoroughly. That way you can make the best choice for your family. After you've decided to hire us for estate planning, we have a design meeting. We sign your engagement letter, we take payment for your estate planning package, and then we sit down and design your estate plan with you. Then I draft your estate planning documents. I send them to you to review, and we meet again to go over them and I explain them. Then you can ask questions and we make adjustments. After we finalize your documents, you pick a date to sign everything, and we typically do that in person at one of our offices in Fairfax or Norfolk, but it is possible to do it virtually in some situations. And then you have a valid estate plan. Congrats. So finally, after all of this, we'll invite you to keep in touch with us. We'll send you information from time to time about estate planning, and we'll ask you to check in when you have major changes in your life. So if you get married, get divorced, you have a big increase in income, you win the lottery, start a business, retire, it may be time to adjust your estate plan. But either way, you should reassess at least every 5 years. And if you have changes to make, we can do that for you and quote you a fee at that time based on your needs. Okay, let's talk about our estate planning packages and fees. So bargains are good when you're shopping for paper towels, but going cheap on a parachute, a surgeon, or a fire extinguisher could be devastating. So estate planning is like anything else. You get what you pay for, and it's worth it to make sure you make the investment to get it done right. Frankly, not planning will cost you more than working with us. Remember, we talked all those scenarios we talked about for probate? So planning could save your family $10,000 to $25,000 and a huge nightmare, even if all you own is a house worth $500,000 and you have minor children. And it could save your kids from losing their inheritance through frivolous spending, divorce, or lawsuit because we can help protect those assets. The good news is that our estate planning packages are substantially less than $25,000. The process should save you time and money. That's the whole point. The whole point is to make it easier for your family. We offer 3 levels of protection: a basic plan, a peace of mind plan, and the platinum plan. We found that most of our clients fall into one of these 3 categories, so you can decide which level of protection meets your family's needs. Of course, if you have a special situation, we'll deal with that as well. The basic plan is for people who want to do a last will and testament. And that makes sense if you have less than $50,000 in total assets or you don't care about probate avoidance for whatever reason. The fee for the basic plan is $3,500 for a married couple, and this includes planning for both spouses. The second level, the peace of mind plan, includes additional protection, including the revocable living trust and a children's trust, which is going to protect the inheritance of your minor children or your adult children if you're needed. The fee for the peace of mind plan is $5,000 for a married couple, and this includes planning for both spouses again. Finally, to add protection from estate taxes, we created our platinum plan. This level provides the broadest possible protection and requires substantially more planning. This is for families who have more than 5 to 6 million in assets and want to plan for possible estate taxes. If you need asset protection planning, that price can vary depending on your needs, but we make sure that you know exactly what it's going to cost before it gets started. So what's really important to know is that all of our plans are based on a flat fee. So before any work begins, you'll know exactly what it will cost. If you're single and you're doing planning for just one person as opposed to two, the fee is $500 less. So let's talk about what comes with the peace of mind plan. And I'm going to talk about that one because this is the option that the vast majority of our families choose. The peace of mind plan comes with everything you see here for both spouses if you're married. You get a revocable living trust for probate avoidance. You get a pour over will that pours into your trust at your death any assets you've left out of your trust during your lifetime. This is also where you name guardians for your minor children. With a peace of mind plan, we can also create a children's trust if you feel you need it. And this is to keep your kids' inheritance in the family. If you have minor kids, we're going to name guardians inside your will, but also in a document outside the will. And we're going to create powers of attorney for you to ensure you have all of the essential planning documents you need if you're incapacitated. So this is kind of a long list of documents, but I want to emphasize that the goal is not just for you to walk away with an expensive binder full of documents. The goal here is peace of mind for you and your family and crafting a comprehensive plan to protect you and your family while you're alive and after death. So my goal is to listen to your concerns, hear about your family and your financial situation, and use my knowledge and experience to create a plan that gives you peace of mind. Okay, so if you're ready to move forward with your planning, the next step is to book your peace of mind planning session. And you can do that by contacting me or our firm, and I or one of our paralegals can set up a time for your Zoom planning session. This QR code right here is a link to my firm's contact information form if you'd prefer to do that rather than emailing me. If you have any questions at all about our process or packages or fees, please feel free to call or email me. Here's my contact information. Go ahead and call me or email me directly. It's absolutely fine. And I am happy to help. So now I'm going to answer some questions from the chat and I will try to get through all of them. Okay, we have some good ones here. I see a couple. And Maria will let me know if there are any others that I'm missing. But the first question I see here is, what is the difference between a revocable and an irrevocable trust? And that is an excellent question. So the biggest difference is that you cannot change an irrevocable trust. It is, you put your assets into the trust, someone else controls it. A third party becomes the trustee and they're in control of the assets. There are many different kinds of irrevocable trusts. We use them for estate tax planning, for special needs planning. If you have someone who's receiving government benefits, if you have someone who's incapacitated and no longer able to care for themselves or their money, then that trust becomes irrevocable. So there are many different kinds, but a revocable trust, which is the type we've been talking about here, is something you set up while you're alive and you control it. So you're the grantor, you are the trustee, and you are the beneficiary. I hope that answers your question. Let's see what else we've got here. Cool. Okay. Okay, so how do we make changes to a trust if we want to? It really depends. I know that's such a lawyer answer, isn't it? No, really, it does depend on what you want to do, but it is fairly easy to amend a trust with your original lawyer. So we do a trust for you, and then later you come back and you want to change your beneficiaries, you want to change how people receive the money, how things are distributed. We can do that with an amendment. And we'll quote you a fee at the time, and it's pretty easy. If you wanted to completely redo everything, we can still keep your trust name and restate the entire trust. But by keeping the original name and restating it, you don't have to retitle all of your assets into a new trust. So we try to make it as easy as possible. And I hope that answered your question. Okay, let's see what else we've got here. Can I move my house into my revocable living trust if it has a mortgage? That is an excellent question. Yes, yes, you can. And it's a good question. And a lot of people ask that because you've all heard about the due on sale clause in your mortgage, right? When you sell your house, you've got to pay off the mortgage, right? So title changes, you've got to pay off the mortgage. So what happens if you change title and put it into the trust? Well, fortunately, there is a federal law that actually protects you. If you're putting your home with a mortgage into a revocable living trust, your mortgage company cannot call it or force you to refinance. So you're absolutely fine. Okay, and those are the major questions that I see right now. Maria, am I missing anything? Page through her, I don't see anything else. So I think that is it for today. And of course, please feel free to contact me if you have any additional questions. I'm happy to help. Thanks so much. Bye-bye.